Welcome to our new podcast series. I'm Sheena Frazer, a partner in the restructuring team, and I'm joined by Amy Jacks, the co-head of our London team. Whilst the relatively new restructuring plan is being well used, we still expect the pre-pack sale to maintain its status as a streamlined and expedient rescue tool. And in this first series, we cover a range of thorny issues that might impact the timeline or the complexity of these pre-pack sales. Today's topic is the challenges you might have when dealing with European assets post-Brexit. Whilst it has always been more complicated dealing with insolvencies that cross borders, for many years, office holders have not had to worry about being recognised in most European jurisdictions because of European legislation that was in place, but that has all changed since Brexit. Amy, can you outline the position prior to the UK leaving the European Union?
Yes, Sheena. As you say, for a long time, we've had the EU insolvency regs and also the Brussels recast regulation in effect, which in basic terms meant that a company's centre of main interest, or as we tend to say, COMI, or where it maybe had an establishment, determined where the proceedings should be brought and also which law should be applicable. Those pieces of regulation also allowed for automatic recognition across member states of the insolvency proceedings. And that meant quick and also cost-effective control of assets that were situated in another member state and avoided the need of opening parallel proceedings or seeking recognition in each relevant member state.
And can you explain a little bit about how that has changed since Brexit?
The issue is that the principles that I've just outlined relied entirely on reciprocity. And of course, once we left the EU, that reciprocity was broken. The existing legislation that I've just talked through no longer applies, and the withdrawal agreements that were put in place didn't actually make provision for continued recognition of office holders or for cooperation in insolvency and restructuring procedures across the EU. And so from 1st of January 2021, an administrator or a liquidator no longer benefits from the automatic recognition that they would previously have had across other member states. Importantly as well, the English law moratorium that we would get, for example, in an administration, which prevents the commencement of proceedings, will no longer be given automatic effect in EU member states. So again, greater risk of parallel proceedings being opened.
So what are the options now available?
There are various things that you can look at. I think probably the two main pathways. Firstly, you've got UNCTRAL, the model on cross-border insolvencies. But there are issues with this. Firstly, it doesn't provide for automatic recognition. Rather, it creates a sort of framework for a court application to be made for recognition. And that recognition is not as holistic as it was under the previous EU reg. And secondly, and really importantly, as you know, Sheena, it's a voluntary framework and countries need to actively adopt it. And within Europe, only 4 countries have actually done that. So you've got Greece, Poland, Romania and Slovenia. So it doesn't really get you anywhere close to where we previously stood. The second option is private international law, domestic law across the EU. So how will that relevant local domestic law in the place that you're seeking recognition treat the foreign insolvency proceedings?
And the application of these domestic laws is by their very nature going to be different depending on the European country you're dealing with?
Yeah, absolutely. And that's really where the issue arises for needing to make sure that you take the time to plan and consider these differing positions where you might previously have been a bit more confident that it would just sort of happen all very naturally and easily. So, for example, picking random countries, if we take Germany, in very broad terms, its domestic law will recognise foreign insolvency proceedings, so long as the court where they were opened does have jurisdiction and the recognition doesn't violate, for example, German public policy. So in the main, again, broad brush, but a UK office holder can deal with assets in Germany. There are still, of course, practical considerations. So again, sticking with Germany, a notary is often involved in transactions there, and it's necessary to make sure that the notary is comfortable that as a matter of English law, an administrator, for example, has the ability to sell the shares under English law. And of course, any purchaser would need to get comfortable. So it may not be entirely straightforward. If you take a different jurisdiction, let's look at assets in Italy. In that country, the courts do have the power to recognise English insolvency proceedings, but whether they will do or not will be determined on a case-by-case basis. And again, in practical terms, you might find that courts away from the main financial centres are going to be less familiar with recognition applications. So, it might be that for assets with significant value, parallel proceedings do end up being considered. And of course, if you've got parallel proceedings or you're looking at potentially lengthy recognition processes, this is just increasing complexity, timeline, of course, cost, and you're also sort of losing the streamlined benefit that you get in an English pre-pack process because you're going to have to deal with these issues in different jurisdictions.
So what do you think will happen in practice?
Well, look, whilst the insolvency rates are now rapidly rising, the vast majority, here in this country, the vast majority are small businesses and very heavily weighted into liquidation processes. So we haven't seen many very large group cross-border insolvencies where this has been an issue. Where we have, and you and I, Sheena, have both looked at these, we have seen different approaches between countries, and in a couple of cases, actually, the decision's been made to just leave certain assets behind because the cost-benefit analysis of realising them, it's just ended up on the matters we've happened to look at not being worth it. And in other cases, it has been addressed and it's been, relatively easy to manage.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayer Brown audio programming, visit mayerbrown.com/podcasts. Thanks for listening.